Hello and welcome. I'm Lisa Harker. I'm director of the Nuffield Family Justice Observatory. And welcome to this In Conversation With. Today we're joined by Nicola Lewis, who's an intermediary who works with the Intermediary Cooperative. Nicola works mainly in the family court, facilitating communication with adults who have a range of communication difficulties. But she also works part-time as an accredited mediator, and she trained and worked as a solicitor. So she brings knowledge of the family justice system from a range of perspectives. I'm going to be talking to Nicola about the support that intermediaries provide, particularly to parents who have learning disabilities or learning difficulties. In June of this year, Nuffield Family Justice Observatory published new research showing that at least 1 in 3 parents in care proceedings involving an infant had a learning disability or difficulty. So we're going to be exploring how intermediaries can help parents navigate family court proceedings. We've had lots of questions in advance for Nicola submitted by our audience. Thank you very much to everyone who sent a question in. But we do also want to hear from you during the event. So please use the chat tab to ask questions or make comments. I'm going to try and make sure we address as many of those as possible. But rest assured, every one of your comments and questions will be read by the Nuffield Family Justice Observatory team, and this helps to shape future research and events. Nicola has also said she's happy to answer your questions outside of this talk, so we're going to be providing some contact details for you. If, like me, you find chat sometimes very distracting, you can disable it. You need to uncheck Show Chat Preview in the Chat tab and keep the chat window closed. And finally, just to say, a recording of today's conversation will be available. So if you'd like to listen to this discussion again, or if you'd like to go back and access our previous lunchtime talks, please visit the events section of our website, nuffieldfjo.org.uk. So without further ado, welcome, Nicola, to today's event.
Thank you.
Let's start by just asking you to explain some background about intermediaries, how they work, who they are. Not everyone on this at the event will know much about intermediaries. We're all trying to piece together how the family justice system works. So give us some background about intermediaries.
Absolutely. Thanks, Lisa. So what is an intermediary? An intermediary is an impartial communication specialist. And our role is to facilitate effective participation. And it's really about two-way communication between justice professionals and vulnerable people with communication needs. And those communication needs could be due to age, so very young or very old. It could be due to any form of disability or disorder, and that could be mental, physical, or a learning need. And intermediaries are really there to improve the quality of the evidence and to facilitate the vulnerable person's understanding and participation in proceedings. So essentially, that's who we are.
And how does someone appoint an intermediary? How does that work?
So there are two ways of finding an intermediary. First of all, if you're working with vulnerable witnesses in the criminal side of things, there's one pathway. I'm not going to talk about that today. In terms of the family court, HMCTS set up a court-appointed scheme. So you have to have the contract to be able to do the work. And in order to find a court-appointed intermediary, you can go to the .gov.uk website, and there's a list of all the HMCTS approved providers. Essentially, a solicitor will usually say to themselves, there's something here in terms of communication that needs looking at. And then they will make an application to a judge, and a judge will approve the application for an assessment to take place. And sometimes it's the barrister who might spot it in court, or sometimes if it's an in-person application, somebody else in the court might spot it. And there's a duty on everybody in the family court to spot vulnerability. So it could be anyone, it could even be the guardian or whatever. And then essentially, once the judge has approved the assessment, the intermediary sets up an appointment via the solicitor to do the assessment, writes a court report, setting out those recommendations about facilitating participation. The judge looks at those recommendations and directs which of those recommendations should be brought into play. One of them is often an intermediary attending at court hearings. Sometimes that's not necessary. It could be any range of measures, essentially.
So, just giving the example that I gave earlier of a parent with a learning disability in care proceedings, what kinds of things would an intermediary be doing through to support the parent through the court process?
Yeah. I think one of the messages I wanted to bring today was there is no parent with a learning disability or a difficulty. There are only people with their own specific different needs. And essentially, communication is made up of many facets of things that influence communication, that impact on communication. So, a learning disability or difficulty might be one aspect. But as your report highlights so well, there is rarely just a person in isolation who just has a learning disability or difficulty going through the family courts. Quite often, there's mental health needs. There can be a lot of adverse childhood experiences that lead and impact on communication as well. There can be trauma as well. And so your average person might be made up of lots of different communication impairments caused by all these differing factors. But if I was to take a standard fit, I would say usually there's going to be a need to think about focus and concentration, a need to think about what they can understand and also what they can say, and also a need to understand within the court environment whether there are things that need to be adjusted so that they can effectively participate. So on a regular day, I might be going to court, sitting next to a vulnerable person once my recommendations have been agreed. And the lawyers, the difference between the criminal and the family courts is in the family courts, there's no jury. And what that means, Lisa, is essentially in the criminal courts, language has to be adapted for a jury. In the family courts, you've got a bunch of professionals all talking to each other, using language that they're trained to use. And sometimes the lawyers aren't even aware that what they're saying is not understandable to a person with a learning need. So my job is essentially simplifying what's going on live in the court most of the time. I might be using visuals as well to help anchor focus and concentration. Or if somebody has a specific learning difficulty, for example, dyslexia, I might be using targeted interventions there. And obviously with mental health, there may be a level of anxiety. I might be working very hard to keep the person's anxiety levels manageable so that they can stay in the courtroom and focused so that they can continue to attend and hear what's going on in the courtroom.
One of the really shocking findings from the research we published earlier this year was that so many parents didn't have their communication difficulty or their learning disability, in this case, diagnosed or even identified until very late in the process. Often, in 75% of cases, it was in proceedings once they'd started, and often very late in proceedings. So could I ask you a bit about masking, what that is, and the sorts of things that we should be looking out for in terms of being attuned to someone's vulnerability when that vulnerability hasn't been, declared or made very obvious at an early stage?
Yeah, I mean, masking is a really major facet of people with learning needs. Quite often, the learnt behaviour from school on, will be to act like everyone else. And if you don't understand, just don't say anything. Make as if you understand. If you know a few of the words in the sentence, try and work out that middle bit. Maybe you'll be okay. And if somebody says, do you understand? Yep, I've got it. I worked with a guy once and his masking technique was to say regularly, I'll get back to you on that one. And of course, what he meant by that is I do not have a clue what you're talking about. But it caused a lot of difficulties for him because throughout the course of the proceedings, there was this thing about him never responding to questions, never getting back to people when he said he was going to. It was a classic sort of masking technique. And in terms of what you can look out for, I mean, it's very much going back to the basics of not asking somebody, do you understand? Of checking somebody's understanding. So in your own words, what did you hear me say? So really drilling down. Also, if you one of the things we do in our assessments quite often is we'll just ask in a very normal voice, do you think the children were being capricious in that story? And your vulnerable person might say, yeah, well, I wasn't there, so I don't know. Yeah, sounds like that to me. And then I say, do you know what capricious means? Yeah. And so, again, as an intermediary, we will continue to focus, particularly when people are giving evidence, on it's okay to say that you don't understand. Or I might have a visual in front of them so they don't have to embarrass themselves by saying that they don't understand that. And they can point to the visual. And then I can say to the court, could that question be asked in a different way, please?
So going to court, particularly care proceedings, but going to any family court is a very stressful experience. It can be quite disorientating for the professionals, let alone the parents. And I said at the beginning, you've come at this from a range of perspectives. You've seen this as a lawyer, and you've also worked as a mediator. What advice would you have for other professionals in terms of how to make the court experience more accessible, and to really ensure that justice is done? In other words, that people really have a chance to fully participate and have their voice heard.
I'm going to say it, Lisa, because it's a very strongly held belief of mine that the way that you know how to assist a vulnerable person with communication impairments within the justice system is to get an intermediary assessment done. And I say that because I feel quite strongly that judges and barristers have very specific things that they need to be doing. But one thing that they're not are trained communication specialists. And to me, it's unfair to pass the responsibility on to a lawyer or a judge who's got their own specific role to play and say, you work it out. You work out something that's taken years to develop into a set of communication needs and communication impairments. You work out what needs to happen. It's, as I said before, there's no one generic. There's not one person. So I can't say to you what you should make sure you do is X, Y, and Z. The intermediary role is looking at the person in front of you, not looking at a label, not looking at, a diagnosis, but what does that person within this court setting need in order to be able to understand what's going on and in order to be able to say what they need to say.
But given we don't have an intermediary for everybody going to court, that's a reality. How do we make the decision about when best to use intermediaries? And are there lessons that can be learned in terms of acting on the assessments, for example? Are there examples where an intermediary can provide some light touch advice, and that in itself can be transformative for parents?
Yeah, I mean, it is our role, if we work well, to be able to put in a report what the special measures are, the communication needs, the adaptations. And also, I mean, I've started really thinking about my practice and thinking, well, if this person isn't going to have an intermediary, what as a minimum could people be doing in court? What as a minimum is going to assist? So sometimes it's adapting the environment. Sometimes if somebody's got a very high level of anxiety, it's a matter of having remote participation for them, or if there's been domestic violence or some sort of history of abuse, having one of the other parties online, potentially with camera offs. There can be little changes like that that can be fundamental, but also just working within the person's communication needs. So it's really hard to say, Lisa, because what judges always say is we'll say short things in simple sentences and then they'll be fine. I don't think I have ever sat through a court hearing where justice professionals have spoken in short sentences using simple words. And if they were to do that, each hearing would take a month. It's the level of simplification required is fundamental. If there's no intermediary, the best that can happen is that there'll be significant breaks taken where the barrister or advocate can take the vulnerable person to one side and check in with them, and also take instructions about information that might have occurred to them during the course of a hearing. But of course, if you're communication impaired, quite often you're not going to be able to retain information. You may not be able to write the notes. So unless it happens contemporaneously in the moment, by the time you take that break with a vulnerable person and say, "Do you get that? Yep. absolutely fine, carry on. Or anxiety might mean all they want to do is actually get out of the courtroom. So without that being managed, again, the needs, there will be difficulty in meeting some of those needs. But I suppose, again, my key message is look at the person in front of you. There's always questions you can ask if you haven't had an intermediary assessment also. Did you have special help at school? Are you sleeping? How's your mental health? Perhaps not asked quite so bluntly, but, how are you feeling at the moment? Are you up and down or are you level? And just try and get a picture of the person in front of you and what their needs might be.
Thank you. You'll be aware that there's quite a debate going on at the moment about the use of intermediaries, and that follows two High Court judgments this year, one by Mrs. Justice Leven and one by Mr. Justice Williams. And I can see in the chat people are already starting to talk about this. So both of these judgments, in effect, have raised the bar for the use of intermediaries. They're challenging how often they should be used, in what circumstances. First of all, have you noticed a difference since those judgments were published?
100%, yes. I mean, but there's two real issues. The first one is that referrers, solicitors, barristers are going to court asking for an assessment, and quite often an assessment by an intermediary is not being granted. And that, to my mind, is the problematic side about what's going on, the key problem, because how can people make decisions about what needs to happen if you haven't even had the input of an expert? So nobody would expect a judge, well, I don't think they would, capacity's fitness to plead. You wouldn't just rock up to court and say, oh, I don't actually think they've got capacity. You would get an expert to opine on that. And then a judge will make a decision. That's the judge's role, to keep the overview in terms of what is required in court. A judge will make a decision about whether an intermediary might be needed or whatever. But without the information, I mean, I feel bad for the judges, to be fair, and the barristers, because they're being asked to pick up the slack, as it were. And I don't think that they have got all the tools, particularly with barristers who are front-facing, and your vulnerable person is sitting behind you in the family courts. How are you meant to work out what's going on, what their needs are? Sorry, but I've gone on a bit, Lisa. Your question was, have I noticed a difference? We have noticed a difference, both in terms of being appointed to assess, and also I've heard judges say things like, well, of course, we're not allowed, that I'm not allowed to appoint an intermediary except for a final hearing now. And to be honest, that really worries me, because that's not in keeping with equal treatment. That's not in keeping with fair access to justice. That's actually imposing something across the board without looking at the person in front of you. And that worries me.
And to be clear, those judgments didn't say that explicitly. They don't hold the status of guidance. So they are questioning when and in what circumstances it's best to use intermediaries. But it's dangerous if that's interpreted as a blanket ban, isn't it?
That really worries me, yeah. And I think the other side is both Leven and Williams, and there's been more judgments by Justice Williams that are filtered through to me. The good thing about them is that they emphasise the importance of intermediaries and the need for specialised intermediaries. I mean, in the Leven case, the intermediary was kept because there was a clear need. In the Williams case, they didn't even need to decide the situation because of various factors. But anyway, for example, I work with the Intermediary Cooperative, and we are all skilled communication specialists. One member, Liz Prosser, she's been an intermediary for 20 years. Before that, she was a specialist in the NHS dealing with brain injury. These are the people who need to be assessing communication. And this is the level of specialism that we are looking at that needs to be implemented across the board. But
I wanted to ask you about that. I mean, is that standard? What is expected of intermediaries in terms of their training? And you can talk about your own organisation there, but also more widely, what background should an intermediary have and what happens in reality?
Yeah. So intermediaries started off, Lisa, in the criminal courts. It came out of the Youth Justice Criminal Evidence Act, Section 29. In 2004, there was a pilot project. It was rolled out in 2008. Intermediaries were a creature of statute created in that way. And in the criminal witness side of things, there's very specific guidelines. You are interviewed, you are roasted by a panel of interviewers, ask very specific questions about your communication expertise. You then have to go on a training course, and you don't even get in unless you have practical evidenced skills in terms of communication specialisms like Liz with her NHS experience. On the court-appointed side, HMCTS have imposed standards, but it's self-regulated in a way. So the organisation has to provide training. HMCTS do regulate to an extent the level of that training, but it's more free flow. So at the Intermediary Cooperative, we don't take people unless they meet the same kind of criteria as registered intermediaries. They have to have skilled communication expertise, which they've worked practically in the sphere carrying out. For example, another intermediary we've got, Vicky Heron, she's been working for 27 years, predominantly with mentally disordered offenders and individuals. She worked as a probation officer, and she's worked for private organisations as well. There's nothing that Vicky doesn't know about mental health. That's the level of expertise that courts should expect. I can only really speak for the Intermediary Cooperative. I know some other providers may take graduates from university because it's not easy to find people like us with a lot of experience. But that's the standards that we apply when holding the contract.
And is the court able to choose, or is there a limited pool that they can draw on? Or they get what they're given in terms of an intermediary locally, or is it possible for them to choose?
It's as simple as a referrer going onto the .gov.uk website or coming straight to the Intermediary Cooperative through our website, for example. For the purposes of this presentation, I counted how many of us there are roughly. And on current numbers that I can see between the providers who hold the contract, there's probably about 167 of us. So when we go back to the leave-in judgment and this whole thing about intermediaries should be appointed very rarely, believe you me, we are appointed rarely in the grander scale of things. You think about your study where you've said a third of parents have learning disabilities. There's 168 of us out there. We're not on every case. Out of your third, we're probably working with the most severe end of need, which is what would be expected. That doesn't mean we're being overused or over-implemented. But essentially, the referrer will make a request of a court-approved intermediary service. And that improved intermediary service, I mean, we match our intermediaries with the right skill set. If you send a referral to the co-op, somebody, for example, if it's autism, somebody with specialist skills in autism takes the work and then delivers the services. So it's up to the referrer to source the intermediary. And if the court wasn't happy with an intermediary, obviously, they could just source a different one.
And geography-wise, are you all across England and Wales? Are there areas where intermediaries haven't reached yet? How does that work?
Yeah, we travel across the UK. Each different service might have people more or less in different areas, but in order to hold the contract, you have to have geographical reach. So anywhere in the country, you can find an intermediary.
Interesting. I've heard judges, barristers, solicitors tell us stories where an intermediary has transformed a case. I'm thinking particularly of examples where a parent's vulnerability has been very hard to identify, hasn't been obvious, but an intermediary has really helped to uncover that and therefore change the course of proceedings as a result. Are there examples which stick with you where you've come away thinking, I'm sure you come away thinking you've done a good job every single time, but are there examples where you think without an intermediary, this would have been so different?
Yes, 100%, Lisa. Yeah, I'll give you two examples. The first one is actually from another intermediary, but it really stuck with me. She worked with a father who was autistic, but he didn't present as, I don't even know how you describe that, because I say everyone has to be judged on who they are, but it was missed. He was a father in family court proceedings, and it was about an injury to his child who had a broken leg. With intermediary support, it became apparent that what had happened is the father had reached through the banisters as his child was about to fall down the stairs, grabbed the child's leg, And by preventing that fall down the stairs, the child has sustained an injury. But of course, when social services were initially involved, it was thought to be a non-accidental injury caused by a father who wouldn't cooperate, who wouldn't speak to them, who wouldn't explain, who wouldn't talk, because he didn't have the ability to do so. So without an intermediary, in that particular case, goodness knows what might have happened, because the same issues that he was having explaining himself to social services would have continued on into court. He would have been seen as difficult and obstructive. And I worked with the most lovely man who was dyslexic, who had 4 children, who had all different communication needs themselves. For a lot of people, dyslexia is can't read, can't write. But actually, dyslexia as an impairment is far, far, far broader than that. Imagine having to carry every single thing in your memory, like a filing index, because you can't write it down. This guy was carrying such a huge mental load that sometimes he was not able to retain really important information. He also was not able to explain himself very well. He had quite a limited vocabulary because of his dyslexia. And again, social services were looking to remove all 4 of his children and to separate them. At the end of the court hearing, he was in tears and he just said, I couldn't have done this without you, because together we worked to ensure that he could give his evidence. I was able to, in my report, explain how he needed to be worked with. And the future projected plan was that he should keep all of his 4 children, but that social services were going to give him the right kind of support that he had not been able to access at all before the court proceedings, because nobody understood what he needed.
They're very powerful examples. I'm conscious that in the examples we have talked about today have been public law cases. Intermediaries are not used very often in private law cases. Is that your experience? And why is that?
We are less frequently asked to assist in private law cases. Why is that? That's a good question. I mean, you could say, your study has shown that perhaps people who come more to the attention of the local authority are people with communication impairments and additional needs. And your study also highlighted the fact that there can be comorbid conditions with learning disabilities, such as mental health conditions and so on. That might be less the case in private law applications. But also, I think it's fair to say people are less aware of intermediaries within the private law sphere, less aware about how to access us. And there could also be issues of funding at times. The court might order that people self-fund in certain circumstances. But I have been appointed by judges, actually. I was phoned once I was having my lunch by a judge who was dealing with a litigant in person and who was aware that there was a significant issue and he was not going to be able to take her evidence on a child arrangements application without an intermediary. So it's about knowledge, it's about understanding, and perhaps it's about balancing need as well. There may just be a greater need in the public sphere.
It's interesting, isn't it? Given a lot of the research we published about families in private law does show how vulnerable they are, and also just how difficult it is to navigate the court process, particularly as a litigant in person. So it's an interesting gap that exists. But as you've explained, there are only a certain number of intermediaries, and the demand for your support is much greater than you can currently meet.
And I mentioned one other thing, Lisa, which about the leave-in judgment, the idea that you just speak in short, simple sentences and use simple words just does not even touch the tip of the iceberg. And the other thing is, judges see what we do in court, but that's such a minor part of what we do across the whole piece. I mean, for a parent to understand what emotional harm is, insight, what the choices are between fostering, special guardianship orders, adoption orders, these are all things. You can ask someone a question. You can ask someone a very simple question like, why don't you do therapy? Now, if the person doesn't understand the implications about why therapy is needed to reduce emotional harm in the future, if they just, if I said to you, why don't you do therapy? You might be a bit like, oh, well, why should I do therapy? Without understanding how it impacts children if you have mental health conditions, quite often the vulnerable parents will be saying, well, I don't need it. So it's about really understanding where they fit in to the whole piece about keeping children safe. And that is a lot of the work that we do as intermediaries, understanding and letting them effectively participate in the court process.
Thank you. You've given us such a brilliant insight today into your work and how it makes such a difference to families. So thank you for joining us. Thank you, everybody who's attended today. We hope you've also found it a useful event. If you'd like to find out more about the Nuffield Family Justice Observatory, and you got our name wrong there, please visit our website, nuffieldfjo.org.uk. You can sign up to receive regular bulletins which contain information about our latest research and upcoming events. We would be really grateful before you go if you would fill in our feedback form, because we read those with great interest and that helps us to shape future events. But finally, thank you again, Nicola, for joining us today. It's been really fascinating to hear more about your role, and see you all at future events.
Thank you so much, Lisa.